Welcome to another Lunch and Learn special edition of Divorce Awareness Week. Welcome to all our registrants, people joining us all over South Africa, joining us on Facebook, on our other social media platforms, LinkedIn, and so forth. Welcome to each and every one of you. Today, we will be discussing the protection of your assets when it comes to divorce. We'll discuss what is the interactions between trusts and divorces, and the implications thereof. So it should be a very interesting talk, specifically when it comes to pension funds, and as well as how to protect your assets when it comes to divorce. Now, Divorce Awareness Week is proudly brought to you by our firm, Oppermans Incorporated. You're most welcome to reach out to us if you need any advice. Please drop us a line on my personal email on eugene@oppermansinc.co.za, or you could use the Lunch and Learn website or the inbox at info@lunchandlearn.org.za, and we would answer any questions that you might have. Now, what we will be discussing today, like I said, we will be discussing assets when it comes to divorce. So what is the assets? What would happen if you are denied your equal share of assets? How to protect your assets during a divorce or even afterwards? What would happen if you hide assets during the divorce process? Is it legal, and what are the penalties thereof? The remedies when a party dissipates assets or get rid of assets during the process leading up to the finalization of the divorce. Simon Dippenard will take us through a recent case involving the tax implications of pension funds, and as well addressing the issue of what happens to your pension fund when you divorce. I will also be addressing what would happen to trusts and how do we deal with trusts when it comes to divorce. And then lastly, Erin would take us through the whole concept of what happens to your will and estate during the divorce process. Just a matter of logistics. If you have registered on our web portal, lunchandlearn.org.za, you would have received a link, and on that link, which would bring you to this website, you could actually stream the live webinar directly from our website or from our social media platforms, Facebook and so forth, YouTube channels, as well as LinkedIn. Those are all the streaming platforms that we utilize, bringing this webinar freely to all the public of South Africa. You will also receive on the link that you would have received on the website, a resource and templates tab right at the top on the right. Now there you could download all the slides that we will be referring to, as well as the complete webinar handout. If we discuss any information, any case law and so forth, that would also be made available on that resource and templates folder or tab that you can access at any time after the webinar. But without further ado, I think we can jump right into it and start off with the topic of how to protect your assets during or even after divorce. Now, this solely depends on your marital regime. How are you married? Because if you are married in community of property, that might differ from outside of community of property, either with or without the accrual. Now, in essence, if you are married in community of property, what would happen to your assets? The assets, if you married in community of property, would be split equally amongst the parties or the spouses. So each and every spouse would have a 50% entitlement to the assets during the divorce. If you are married outside of community of property with an accrual, then obviously, as the Act says, that you are entitled to half of the growth of the asset value of the other party. So there is a certain calculation, the asset accrual calculation, that needs to be done in order to establish what amount you are entitled to when it comes to the growth of the assets of the other spouse. Obviously, when you are married outside of community of property without the accrual is not applicable, there was no antenuptial contract signed, then obviously that is considered to be two separate entities, and the assets that you accrue during the marriage is then solely just yours, and your other spouse or your spouse would not have access to that assets as well. So how do one protect our assets during or even after divorce? Now, before divorce, yes, vitally important there is the establishment, if you have assets before the divorce, that you sign an antenuptial contract in order to safeguard those type of assets. If you are married inside of community of property, that would obviously mean that all the assets that you accrue during the whole period of marriage falls within the joint estate. So your other spouse would share equally in the proceeds of that asset. So there would be no reason, there's no protection when it comes to the in community of property. During the course of a divorce, how do you protect your assets? Now, remember, it depends on how you were married. If you were married inside of community of property, it means it falls under the joint estate. If you get rid of assets or hide assets, if you are married inside of community of property, that has a direct influence on the other spouse. And certainly there are remedies available to that other spouse in order to stop you from participating or getting rid of those type of assets. After the divorce, yes, obviously by that time you've learned your lesson, and you would have realized that the best way would probably be to enter into a next marriage, if you ever venture out to that way, to do a antenuptial contract where all these items, all these assets that you want to protect is excluded from the joint estate. One thing that one needs to bear in mind is that the protection of assets that we discuss here does not mean the hiding of assets. Hiding of assets is an absolute no-no in terms of the South African law. And if the judge or the presiding officer actually feels that you are hiding assets, there might be some severe consequences when it comes to that. So the protection of asset does not equal the hiding of assets, but we will discuss that in a couple of slides afterwards. Like I mentioned, probably the best way of protecting your assets when it comes to a divorce or even a marriage would be to safeguard your assets well in advance before you actually get married. In terms of being married, then obtaining a antenuptial contract in terms whereof your assets by that time would be safeguarded. And that is done before you enter into the marriage, and it's usually a skillful attorney that would draft the antenuptial contract, getting to the base value of what the assets are that you want protected. I always advise other attorneys to avoid unethical techniques or tactics. Yes, there are unscrupulous attorneys out there that advise their clients to hide assets and so forth. And inevitably, those type of hiding of asset comes to the light when it comes to discovery and the whole trial period. And then the judge or the presiding officer might take a dim view of the attorney advising the client, and that might actually amount to unethical conduct. So just be careful with regards to that. Now, Simon Dippenaar, a good colleague of mine in Cape Town, he actually did a talk on specifically hiding of assets when it comes to divorce. And I'm going to hand over now to Simon, that he actually tells us and explains us more with regards to the hiding of assets.
Are you going through a divorce and convinced your soon-to-be ex-spouse is hiding their true financial position? Hi, I'm Simon Dippenaar and I'm a family attorney. I recently spoke to you about maintenance. I mentioned that both parties in a divorce are obliged to provide proof of their income and expenditure, and it's not a good idea to hide salient facts from your spouse or lawyer. However, this unfortunately happens all too often, particularly when the marriage is in community or property. In this matrimonial regime, all assets are split 50-50 on divorce. Now, why would anyone misrepresent their financial status? Surely they entered into marriage knowing the consequences when they chose their matrimonial regime. Well, the breakdown of a marriage is an emotional time. People who are normally rational and fair can behave uncharacteristically out of hurt or spite, especially if they feel they put much more time and effort into the couple's financial status than their partner. They may think it's unfair for their spouse to get half of what they have worked so hard for. Concealing assets in the context of divorce negotiation can be done in a number of ways. The individual may simply not declare them, may depreciate assets beyond their current value or may conceal the extent of the assets. They may also overstate debts to appear insolvent, report income to be less than it really is, and claim expenditure to be higher than it is. You might think financial transactions are easily traceable, so it must be difficult to over or underestimate the reality. But for a business owner or anyone with complex financials, which is most of us these days with multiple credit cards, loans, online accounts, it's actually quite easy to cover our tracks. Many couples maintain separate bank accounts with a joint account just for shared expenses. If you think your spouse is hiding assets from you, look out for defensiveness when the issue of finances is raised, receipts from ATMs or credit cards or accounts you don't recognize, large withdrawals from a joint account without discussion. Specifically, there are some red flags you should not ignore. I'm going to describe the main ones. Your spouse claims that a computer containing crucial financial records has crashed and can't be restored. During the discovery phase of the divorce, when both parties are required to disclose their assets, they report a decline in the value of marital and or business assets and investments. They probably transfer these assets to family or friends and will reverse this after the divorce. They become shifty about banking details and take control of bank accounts where historically there has been openness. They open several new accounts, possibly in the name of a child. If they're a business owner, they fail to reimburse their own business expenses, overpay creditors or prepay suppliers. This money can be refunded later. Family or friends are put on the payroll or paid for fictitious services rendered, which will also be refunded later. They make extravagant purchases which can be sold on for cash or which reduce the amount of cash in the marriage. A new cell phone with a different number is highly suspicious, as it may be used for transaction notifications and other illicit interactions, though they are likely also to hide the existence of supplementary device. Their income suddenly seems to decrease. This is harder to feign on a fixed salary, but a tactic a business owner or self-employed person might use. They appear to stop receiving commissions or bonuses. These have, in fact, been delayed until after the divorce. They pressure you to sign legal documents quickly, so you are not fully aware of what you are signing. Fans of Chicago Fire on Netflix will remember this ploy. On a personal level, they complain about money or debt, or vague or circumspect about their financial affairs, or claim their business has already failed. They submit false, underreported tax returns and pay more than they owe to SARS. They will be rebated for them later. Any one of these actions should set alarm bells ringing. Anyone truly intent on disguising their true financial position is probably also smart enough to conceal their actions, but some of these will be apparent. In fact, are intended to be obvious, such as a drop in income. If you become aware of any of these signs, bring them to the attention of your lawyer immediately, and don't ever sign anything you are not comfortable signing. Read it thoroughly, and if you don't understand it, ask an attorney to go through it with you.
Thank you for that, Simon. Now, that brings us to the financial disclosure form. Now, this is a form that was introduced mostly in Gauteng, and I see it spill over now to the Western Cape as well, where parties in a divorce proceeding needs to complete a financial disclosure form. Now, this is a form that was created stipulating all the assets and all the expenditure, all the liabilities that needs to be put forward to court, so that the court could actually evaluate and gauge apples and compare apples to apples by parties not giving the correct information. Now, this document, it's a well-renowned document, especially like I said, in the Gauteng area. The Western Cape now is enforcing that quite a lot as well. We're waiting for directives so that needs to be implemented. And I've been using that practice quite some time now, especially in maintenance matters as well, to request the other party to complete the financial disclosure form. So that we could actually see what is it that they have, what assets do they have, what are their liabilities, what are their shares, what are their company shares, and so forth, in order to get an asset base or to get a value thereof. Now, the financial disclosure form I have copied to the resource and handout tab. You can find it there. I can briefly run through that, which is quite a standard document. But as we run through it, you will actually see that it is a document that is well thought through. It is done under oath. So at any stage that you lie with regards to information pertaining to this document, you might open yourself open for perjury. It is a very self-explanatory form that needs to be filled in by both parties, giving the general information of the parties, the names of the children as well. the details of any other pending cases that might be there. It might be Rule 43, Rule 58, Children's Court, Maintenance Court, and so forth. That just gives the magistrate or the presiding officer an indication of what legal processes are they still at play when it comes to the divorce, finalization of the divorce. Then we bring Section 2 is the financial details. It gives you the immovable property and the personal assets, things like what is the IRF number, what is the mortgage account number, who holds the mortgage bond, who pays for that, and so forth. And then you get a total value thereof. Like I said, it is quite explanatory. You also need to divulge all your banking details. Please do not hide your banking details, because the registrar of the court can apply, or even the attorneys can apply to court for an order to investigate to see what type of accounts you do have. So please do not hide that, because they will pick it up on your ID number as well. That is in order just to get you a total value of the interest of all bank accounts that is under your name. Same goes for investments that you might have. That also includes cryptocurrency, insurance of or life endowment policies. That is in order just to get a cash basis or cash value of that. Some of the life policies or the endowment policies do have a surrender value. And obviously, depending on how you were married, then your spouse might be entitled to a certain portion thereof. So it's quite important that you get the type of policy as well as the policy number. If you could also ask your broker for a printout of the documents of the details of the policy. Personal belongings, and then you add them all up to say what is your asset base. Next, we come to the financial details with regards to liabilities, who you owe money to, what amounts you owe money to, your business interests. If you do have a business, that is easily picked up on the SIP-C portal, where you can see who is the director, if it's still active. And obviously financial statements also needs to be submitted. Those are all I'm not going to run through the whole document. We have done a whole Lunch and Learn webinar specifically on the financial disclosure form, which might be of interest to some of the people. Income-based arrived from employment. Yes, your IRP forms and so forth also needs to be submitted at least for the past 3 years. Pay slips as well. Those are all documents that we usually tend to forget in order to establish what is the total asset base of a person. So if you run through this form, then you can be sure that you have not left out anything of importance that might have an influence on your entitlement in terms of the marital regime. Going through that from state benefits, that might be government grants, SASSA grants, and so forth. You have to name those as well. Other incomes, if you have rental income from a holiday home, Airbnb, and so forth, you also need to include that together with the financial statements. That is basically the financial disclosure form, and one could actually see that there is great benefit of both parties completing this form, so that you can actually compare apples to apples and to get the true situation of the financial status of both people. It also makes provision for maintenance. If you need to pay maintenance, what are the amounts of maintenance? That's why we also use it in maintenance matters. Let me just see what else we can mention. Yes, right at the end, it is done an oath or an affirmation that it is the truth. So you might open yourself for perjury if you do not divulge all the information on that document. That is basically the financial disclosure form. It is also available on the resource and handout tab, where you can have access there to and download it. It is in Word format so that you can change it and you can complete it and you could fill it in completely right there. So next up, yes, we discussed the financial disclosure form. So the remedies when a party, say for instance, the parties are married outside of community of property with the accrual, that is mostly the cases that we deal with, and that is usually also the biggest problems, the high conflict divorces, because it's all about money. Divorce is very seldom about emotion. It's mostly about the money. People split up and then they like Simon also mentioned, they feel aggravated because they contributed towards the home and so forth. The other party might not have contributed as much, and now they're a little bit revengeful or vengeful when it comes to the splitting of the assets in terms of the marital regime. So let's just basically talk about the accrual system. Like I said, what is the accrual system? What is an accrual calculation? That is basically where the parties are married outside of community of property with the inclusion of the accrual, and they have signed an antenuptial contract before they entered into the marriage. Now, in terms of the legislation, it says that you are entitled to half of the proceeds, the growth of the proceeds of the other party. And that just brings the parties to an equal base. So when is the value of the spouse's accrual calculated? It is usually done by the end. When the marriage dissolves, then the calculation is made. Obviously, we do not wait up until the time that divorce has been finalized before we do that. We do the calculations beforehand, because if we do have the financial disclosure form, then we would be in a position to actually establish what was the growth of the individual spouse's estate before the termination of the marriage. So who determines the accrual calculation? Usually it is done by attorneys. In very, very often what happens is that they employ the services of an actuary or a bookkeeper or an accountant in order to assist with all these paperwork. Because after all, we've studied law, and we do not do the number crunching when it comes to assets and so forth. So what are the remedy if one of the spouses, if you are married outside of community of property with the accrual, what are the remedies if one of the parties dissipates or get rid of assets while the divorce is still pending? So Section 8.1 of the Matrimonial Property Act came to the rescue, and it said that a court may order the immediate division of the accrual if a spouse demonstrates to the court that their right to a share in the other spouse's accrual will be seriously prejudiced. So there is a remedy available that if the one spouse is busy hiding assets, or they're getting rid of assets in order to make their accrual amount as little as possible, that you could approach the court in terms of Section 8.1 to get an order for the immediate division of the matrimonial property. So how is that done? You need to satisfy the court of a couple of things. It's not an easy process, but it is in the form of an application to the High Court or the regional court. And in terms of what you need to tell the court, you need to satisfy the court that obviously that the marriage is subject to the accrual system, and that you have a right to share in the spouse's or the other spouse's accrual upon divorce, and that there would be a significant prejudice if the other spouse continues with his conduct of actually getting rid of all the assets, because that might have a direct influence on your financial amount that you would get from the accrual. And lastly, you also need to show the court that the immediate division would not prejudice any other person in the marriage, obviously the other spouse. Now, I want to refer you to basically there's only two cases that I would briefly would like to discuss, which would give you some more clarity with regards to the accrual system. The one is a recent case that was handed out last month, SM versus JM, and another where the applicant sought an urgent interdict preventing the respondent from selling or disposing the matrimonial home pending the finalization of the divorce. So he wanted to sell the house while they were still married, but they were married outside of community of property with the accrual. So the applicant now seeks then for an anti-dissipation interdict, and in the event that the property has already been sold, that the proceeds thereof would be kept and paid over to an attorney's trust account up until a stage that it could be divided and the divorce proceedings have been finalized. Now, very interesting in this case, the judge made a couple of comments with regards to specifically this scenario, and he mentioned that, you know what, during the marriage of of parties married outside of community of property with an accrual, each spouse owns and controls his or her own estate, because they are separate, and only at the time of dissolvement of the marriage, then the court would look at the growth thereof. So neither spouse has any right or claim to any assets while they are still married. During the subsistence of the marriage, they are not entitled thereto. So they cannot say, I want that during the whole period that they were married. Section 3.1 of the Matrimonial Property Act clearly says that it is only upon dissolution of the marriage that the sense of entitlement, that you become entitled to that amount. So the right to share in the accrual of the other spouse's estate arises only, or the right to share arises when they get in, when they started with the marriage, when they entered into the marriage, but the dissolvement and the actual receiving of the benefits would only happen after the divorce. That was the one case that I wanted to bring your attention, which was quite a recent case, and it just reconfirmed what we already know with regards to that. Turning now to tax and the pension funds. Now, pension funds, when it comes to divorces, is clearly governed by the way that you were married. We've mentioned the types of marital regimes, the in community of property, out of community of property, the one with accrual, without. We've mentioned those, and that would have a direct influence on what would be your entitlement when it comes specifically to pension funds. So if you are married in community of property, the pension interest of the spouses will form part of the joint estate of the parties. And the non-member spouse will be entitled to claim half, 50% of the pension interest of the member as at the date of divorce. So there's a calculation to be made at the date of divorce, and you would be entitled to 50% thereof. Marriages out of community of property with the accrual, where they are married out of community of property and they do have an antenuptial contract, the spouse's pension fund value will be taken into consideration in order to determine the value of the growth of the estate for purposes of the accrual calculation. Marriages out of community of property before the 1st of November 1984, that's handled a little bit different, because there we work with redistribution of assets in terms of Section 7.3 of the Divorce Act. We do not get a lot of those, but yeah, the older, like we call the grey divorces, people married before 1984 most definitely falls under that category. Marriages out of community of property without the accrual, so there's no accrual, that was entered into after the 1st of November. There, obviously, the spouses retain their separate estates, and there is no sharing of assets during the divorce. They do have two separate entities. They're completely independent of each other, and any share in the pension or interest of the other one, of the other spouse, would only happen upon mutual consent. Now, remember that if you enter into a settlement agreement, then the parties can actually agree that one party might share in the benefits of the pension fund of the other, if they're so inclined, and if they so do agree with regards to that. Now, what is the pension interest? There was quite a number of cases dealing specifically what is considered to be pension interest. It is not interest as we know it, where you put money in the bank and you accrue interest. Interest, as defined in the Divorce Act, is for every type of fund except a preservation fund. According to the Pension Funds Act, the Pension Act, or the pension interest, actually means, in terms of pension and provident fund, the benefits to which a member would have been entitled to in terms of the rules of the fund at the date of divorce. So they would say, you know what, as if you resigned from that or terminated from that pension fund or provident fund, the value at that stage, what would that be? And that is considered to be at the date of divorce, and the other member would be entitled thereto. The Act also recognizes retirement annuities, that is the sum of the members' contributions to the fund up to the date of divorce, plus a simple calculation of annual interest at the prescribed rate. Preservation fund is it's a little bit different. The benefit of a fund member would receive if his or membership were notorially to terminate on the date of divorce. So that's tackled a little bit different, but because pension interest is quite a contentious issue, and there's a lot of calculations that needs to be done, my advice would be to seek legal counsel and maybe the services of an accountant dealing specifically with pension and the inner workings thereof, because it might become tricky, specifically when it comes to tax and so forth. So just as a matter of interest and a matter of importance that I would bring to the attention to either the mediators out there doing mediations, settlement agreements, is the citing of the fund in divorce agreements. I have seen so many instances where parties come to my office afterwards and they want to change the wording of the settlement agreement because it was not properly done. It is vitally important that the correct name of the retired fund is used. So the correct name needs to be used, because if you do not do that, then the situation would definitely present itself where the fund would not pay out. Divorce settlements are frequently drafted using only the name of the insurance company that manages the funds. For example, Old Mutual or Liberty Fund and so forth. These are financial institutions, organizations, and they operate where they have numerous retirement funds that they manage. The specifics needs to be mentioned in the divorce settlement. So my advice would be that the divorce order must contain at least 3 things. The one is specific reference to pension interest must be made as defined in the Divorce Act. If the fund is a preservation fund, the order must read the pension interest as defined in section 37D6 of the pension fund. So make a clear distinction between what you ask for and what reference there is to the Act. Obviously, the name of the fund needs to be stipulated in as much detail as possible. Include the policy number if it is available. If you completed the financial disclosure form and you had access to the broker notes and the broker breakdown of your pension interest, then include the number, the pension fund number on there as well. Lastly, is also what needs to be included is a specific percentage or an amount that the pension interest must be provided. Do not keep it vague to say, 50% or 20% of the pension interest, just as a general, as a blanket. Make it as specific as possible, and also give time frames and dates upon which that might happen. If you just leave it open, I've seen many of those divorce agreements where they just say, the one spouse is entitled to 50% that needs to be paid over, but there's no time periods. And the funds actually took up to 2 years to do that. Usually there are prescriptions and directives for the pension funds, the time limits that they need to do the payouts. But if there is no sense of urgency and it's not governed by a court order, then they usually take their time, and it could take up to 2 years. So my advice would be to include those time frames as well. Speaking about taxes, yes, that is also a very contentious issue. And again, I advise you to seek legal advice with regards to that, someone that specializes in tax, specifically divorce tax and the payment of pension benefits, or to seek the advice of a qualified accountant or an actuary that could actually assist you. As a general rule, the non-member ex-spouse will pay the tax on the pension interest if he or she takes the benefit in cash. So if they they say they want the cash value thereof, then they are liable for the tax thereon, if it is so stipulated in the divorce settlement. If it is, however, if it's transferred to another retirement fund, then the transfer thereof would be tax-free and you would get the full benefit thereof. It is, like I said, a very difficult area, according to the pension fund attorneys and also the Pension Lawyers Association of South Africa, especially when it is when the pension interest is quite a large amount, because the tax implications thereof might also be simultaneously very large. And then it is very much advisable that they obtain professional legal advice, specifically with regards to the pension fund interest. Next up, Simon did a short case that he did in Cape Town quite a while ago, specifically with regards to the tax, which I thought that might be very interesting. Over to you, Simon.
It can sometimes be difficult to understand the intricacies of divorce proceedings, but the following case might help to explain what sorts of issues can arise and how they might be resolved. Hi, I'm attorney Simon Dippenaar. In a recent case at the Civil Regional Court in the Western Cape, a dispute took place between a divorced couple. In terms of their divorce court order, an amount of approximately 500,000 rand was to be paid from one party's provident fund to her former spouse. The payment was made by the fund, but tax was first deducted from the final amount. The issue being disputed was who was liable to pay the tax, the fund member or the former spouse. The fund member pointed to the divorce court order, which said that her former spouse would be liable for any income tax for money he received. His counsel, on the other hand, argued that he had not yet received the amount and that the tax was therefore not income tax. Ultimately, it was revealed that the former spouse could have avoided the tax implications if he had chosen to reinvest the funds in a pension fund. But he chose to receive the money in cash and was therefore liable to pay the tax that was due. These sorts of circumstances or issues can be complicated and require the intervention of experienced lawyers.
Thank you for that, Simon. Very well said. And it's important to note because you might sit with a situation where you think, oh, you get a certain amount in terms of the pension fund, and then you get slapped with a SARS note that you have to pay a considerable amount of tax on there as well. Advice again, speak to a legal practitioner specifically with regards to the tax implication. The next clip that I would like to show you is a SABC interview that was done specifically to pension funds, which you might also find very interesting.
Let's get clarity on this issue. What does the law say? Let's get clarity on this issue. What does the law say about disbursement of a pension fund during divorce?
It says that if you are married in community of property, each party is entitled to the other party's a percentage of the pension interest. Now, the Act doesn't prescribe what that percentage can be, but typically if you're married in community of property, that will be 50% of your pension interest. And pension interest is loosely defined as what you would have gotten if you got divorced on the date, if you resigned on the date of divorce. So if you were to get divorced today and your total benefit in your fund is R1 million, that would be 500,000 if the non-member spouse is entitled to 50%.
Mm-hmm. Now, the validation of marriage is not questionable if it has been fortified. Now, does it mean that if anybody gets married to you as soon as yesterday and you have R1 million, does it mean that when that person says, I said I loved you, but I lied, and they get half of your pension, say from R1 million, now they are 500,000 rand richer?
Unfortunately, that is the case because the Act doesn't say it only applies to the benefit that was built up since you got married until the date of divorce. So it's whatever the member had in his fund on that day.
So now how does a divorce settlement and a maintenance issue affect the fund? Because if we share R1 million and I have 500,000 rand and you have, if there are children involved, there is still another ripple effect because the children will have to be maintained in terms of clothes, food, school fees, and so forth.
Normally, if there is a maintenance order, you would expect the party against whom it is to pay the maintenance out of other funds, not his pension benefit. The pension benefit only comes into play if that person doesn't pay. So you have to be in arrears with your maintenance before the non-member spouse can go to the fund to claim that portion.
Mm-hmm. Does this then not defeat the purpose of investing, because retirement is supposed to be saved for in a fund that would grow the money. Then what does this really have an effect, and how does it have an effect on the purpose of investing?
It is actually disastrous. Let me just illustrate. Let's say we have the case where the benefit was 1 million and you gave away 500,000 of that. Now that 500,000 is then taken out of your pension benefit and paid to the non-member spouse immediately, which means that what you have left in your pension fund is the 500,000 that now has to grow to what you would have had. Just compare that to what you would have had if it was 1 million and it grew up to your retirement, which is, let's say, 15 years from now. So you don't only lose that lump sum that gets taken out of your pension fund, you also lose the growth on that.
So you the future interest is taken as well?
Yes, because if the capital is taken out, then the interest that you would have had on that is also it's gone. Remember, I take the 500,000 out and I give it to somebody else. So the growth will then be somebody else's, not yours.
What is then your financial advice to somebody who's getting divorced and doesn't want to be affected on the downside of the risk of getting divorced?
Find another asset to divide. There might be something else. Let's say you've got a house that you can sell. But please don't touch pension benefits, because, as you rightfully said, it defeats the purpose of the pension fund. It's not there for you to have access to cash whenever you need it. It's there to provide for you for retirement. So if you wanted to provide for retirement, keep it there for as long as possible.
Very, very, very valuable information from Hetty Uber. She is from Momentum Employment Benefits. And the takeaway from this would probably be, if you can at all means not touch your pension fund, because that is for your old age. If you do not have to touch that, and you have other assets that you could realize into money, holiday home and so forth, that you would rather use that in divorce settlements, in order to make a fair and equitable distribution with regards to that. Next that I would like to discuss is pension funds, or not pension funds, divorces and trusts. Now, trust has become quite popular nowadays as a vehicle, as a legal entity to operate. It could be a family trust, it could be a business trust, and so forth. So what happens if there's considerable amount of assets that is held in a trust by one of the spouses, even if they were married inside of community of property or even outside of community of property? What happens to that trust? Because that is considered to be a separate entity, and it's not taken into account when the divorce proceedings comes to an end. So the law now states that the trustee does not acquire ownership of the trust property, but they just hold it to the benefit of the designated beneficiaries. Consequently, the trust property is typically not included as part of a person's estate when determining the value of an estate in divorce proceedings. So that is excluded. But in a recent case in 2006, the Badenhorst versus Badenhorst case, the court actually ruled that if it can be established that a trust is being used as an alter ego of a party, of one of the spouses, and the assets held in that trust is done on a malicious way or not a correct way, and it is done as an alter ego, as a front to hide assets, then definitely that could be included in determining what that party's means and financial status are. So how does this happen? What is it that one needs to prove to court when it comes to something like that? If you do have a business trust or a family trust and you are a trustee thereof, then most definitely, if the trust has considerable assets, then you can approach the court to have it declared as an alter ego or sham trust during the divorce proceedings, so that you could actually lay your hands on some of those assets. So what is this necessities? What is the requirements that you need to prove to court? Number one, you have to prove that such spouse controlled, one of the spouses controlled the trust, that he was in total control thereof, he made all the decisions, and so forth, irrespective of the terms of the trust deed. So even if the trust deed said that they were 50-50 and they had to have consensus on certain things, and the one party operated as if he was the owner of the trust, then consideration would be given, and that would be seen as evidence of how the affairs of the trust was conducted during the course of the marriage. The other requirement would also be that the question that if without the trust, would that spouse still have acquired and owned assets in his or her own name? Those are basically the two requirements that the courts would look at when it comes to lifting the trust veil. We call it lifting the trust veil, very similar to lifting the corporate veil in company law, where they would actually go into the trust, the details of the trust, and look at the assets of the trust and take that into consideration with the dissolution of the marriage and how it pertains to specifically the financial implications of both parties. So be careful and be very, very wary about trusts when it comes to the division of and the drafting of settlement agreements in divorce proceedings. Lastly, what we will be discussing now is how divorce will affect your wills and estate. And I would hand over to Erin that would take us through this portion of the presentation. Over to you, Erin.
How does a divorce affect your will and your estate? Very interesting. As a point of departure, remember something. You are only divorced once the divorce has been finalized by a judge. So once the judge signs the divorce order, then you are divorced. Up until that point, you are not legally divorced yet. So you always have to update your will, because during the time period where you are getting a divorce, but it is not yet finalized, and your spouse is mentioned as a beneficiary in your will, that spouse will still inherit, even if you do not intend them to. So, for example, you are now currently instituting divorce proceedings. The divorce is not yet finalized because the judge has not yet signed the divorce order. During that time, you die, leaving a will in which your spouse was a named beneficiary. Your spouse will inherit in terms of that will, given that you are still legally married, that person's named in the will, and so that person will inherit even if you did not intend them to. So it is very important that you update your will, update the beneficiaries in your will. The Wills Act does provide some form of protection. So in terms of the Wills Act, that if you die within 3 months after the date of the divorce, so after the divorce has been finalized, your spouse will not inherit, even if they were named in your will. This is because the court basically gives you 3 months in which you can update your will. But then the same is true that if you die more than 3 months after the divorce has been finalized, your spouse will inherit if they are mentioned in your will. This is because it is believed that 3 months is more than enough time to update your will. And if you have not updated your will within 3 months, it is assumed it is your intention that your spouse should inherit. So it's very important. Wills Act does provide some protection, meaning that if you pass on within 3 months after the date of divorce, your spouse will not inherit, but this is only after the judge signs the papers. But if you die in the interim period during instituting divorce actions and the case is still ongoing, then your spouse will inherit in terms of your will. However, if the divorce is granted within that 3-month period and then you die, your spouse will not inherit. If you pass on after 3 months from the date of the divorce, then your spouse will inherit if you never changed your will. So therefore, the argument is simple. 3 months is ample time to change your will. And if you fail to do so, then it is assumed that it was your intention to let your ex-spouse still benefit out of your deceased estate. So just always remember to update your will as soon as the divorce process starts. Don't waste time. Update the beneficiaries in your will. Another important aspect to consider is that in terms of life insurance policies and pension funds, you should also update those beneficiaries. Make sure that as soon as the divorce process starts, you notify your insurance company, notify your pension fund of any change in beneficiaries to the policy. This is very important. And then another thing that becomes important is this document known as a power of attorney. If you had given your spouse a power of attorney during the time that you were married, it becomes so important to make sure that you revoke that power of attorney, because you might not want your spouse to control your affairs after your death anymore. But then you have to change that. So if you don't update your will and you go through a divorce, there could be serious repercussions for your deceased estate. So always keep that in mind. Always keep in mind to update your will, because the Wills Act does provide some form of protection, but only to a limited extent. Update the beneficiaries on your life insurance policies and also on your pension fund. And remember that as soon as the divorce process starts, update your power of attorney. So those are the 3 important aspects to consider: how a divorce will affect your will and your deceased estate. Thank you. Back to you, Eugene.
Thank you, Erin. I saw that you just left out the last one, and that is update the signing rights at bank accounts. If you and your spouse has a joint bank account, one bank account for both parties, and they both have signing rights, it might also be a good idea to change that so that you are the sole signatory of that bank account. Very, very interesting to note that there are quite a number of things that needs to be done after divorce or even during the divorce process in order to safeguard yourself. Note to self, if you ever do get married again, make sure that you do have an antenuptial contract in order to protect your assets, as well as update your will regularly when it comes to divorce proceedings. To round off, I might mention, it's notable to mention that we have a couple of ebooks. I've included another ebook there. It is basically on economic abuse, which we will be discussing in a day or so. These are all ebooks that have been written by attorneys, by myself and some of my colleagues, without the legal jargon. So it is written in plain, understandable English. Please download that. You can download that from our website, www.oppermansinc.co.za. If you have any questions or queries regarding some of the ebooks, or you do not understand a portion thereof, please reach out to us, and we will most definitely give you some clarification on the understanding thereof. Thank you so much for joining us. I would like especially to thank Simon Dippenaar for his inserts and for his clips that we could use. The Divorce Week, or the Divorce Awareness Week, was proudly presented by our legal firm, Oppermans Incorporated. If you do have any legal problems pertaining to divorces, or any questions or any comments even, please drop us a line on our personal email. My personal email is eugene@oppermansinc.co.za, or you could use the Lunch and Learn inbox, info@lunchandlearn.org.za. Thank you so much for joining us. We hope to see you soon for another episode. And the conclusion, we still have a couple of more to go, the conclusion of our Divorce Awareness Week. Please do read the disclaimer at the end of the slideshow. Thank you so much for joining us, all the registrants that have registered, and all those people joining us from our social media platforms. Thank you so much, and have a good afternoon further.